Hi, can you hear me? One person watching, can you hear me? Okay, not sure if y'all can hear me, but I'm just going to go ahead and read through this. So this is Reporters Committee for Freedom of the Press, which I believe is a national or maybe international organization, and this is specific to Washington State, which is the state where I have received a nuisance lawsuit from. Washington, by RCFP Senior Staff Attorney Sarah Matthews and legal intern Maya Gandhi, Georgetown Law School, class of 2023. I was supposed to be many law schools class of 2023, but here we are in 2024 and I still only have 24 credits when you need like minimum of like 87 to 90. So there we go. In May 2021, Washington enacted a version of the Uniform Public Expression Protection Act, UPEPA, which went into effect July 25th, 2021. The Uniform Law Commission drafted UPEPA as a model law designed to prevent abusive litigation, known as strategic lawsuits against public participation, or SLAPPs, as Lima would say, and she's the queen of SLAPP lawsuits, aimed at silencing free speech through meritless defamation, privacy, or other nuisance claims. Although Washington was the first state to adopt the UPEPA, several other state legislatures are now considering whether to do the same. See why she didn't file in Washington State, where she allegedly lives and runs her business? Because it has a very long-standing, very robust anti-SLAPP statute, just so you know. The new law applies broadly to suits based on a person's exercise of speech, press, assembly, petition, and association rights on a matter of public concern. UPEPA 2021, Washington Legislative Service, Chapter 259, Section 2, Paragraph 2C. It also applies It also applies to lawsuits based on a person's communications in a legislative, executive, judicial, administrative, or other government proceeding, and to communications on an issue under consideration by any of those bodies. Section 2, paragraph 2A, paragraphs 2A and B. The law carves out some exceptions to this broad scope, including for suits brought by government agents to enforce public safety measures. Section 2, paragraph 3. This lawsuit against me does not fall under any of those. So far, I'm very confident. To challenge a SLAPP suit under the Washington law, defendants have 60 days after a claim is brought to file a special motion for expedited relief to dismiss the suit. Section 3, paragraph 2. Also, unlike in the standard version of UPEPA, the Washington law requires the defendant, that would be me, to give notice to the plaintiff, that would be the ringmaster, at least 14 days before filing, allowing the plaintiff to withdraw or amend the complaint, or the defendant loses the ability to recover attorney's fees. Section 3, paragraph 1. Okay, so what I'm reading so far is there's a Zoom hearing on January 9th. At that hearing, I can give 14 days notice to the plaintiff, the frivolous, meritless, vexatious nuisance plaintiff, who we'll just call the ringleader. Oh no, sorry, the ringmaster. Britney Spears is the ringleader. 'Cause I'm the ringleader, I call the shots. This buffoon, this clown is the ringmaster. I'll always remember master because it sounds like something from slavery, and that's what this feels like, is I'm their slave because I refuse to accept their love bombs and other attempts to control me. So now they're trying to take my voice away. Okay. So let's see, word for word of what we got. Okay, so I could take up to 60 days to do it, but the sooner I do it and put them on notice, and if they decide not to withdraw their complaint, well, then they're going to have to pay me attorney's fees the same way Lima had to pay BJ's attorney's fees in California. Okay, I'm understanding this now. Even with my shitty, barely, got a C in some of my law school classes, I'm understanding this. Maybe I don't need to waste money on an attorney, or if I do, I can be confident that that attorney will get paid by this plaintiff and not by me. Although this plaintiff is probably going to claim that they're destitute and like living in a basement and in a pyramid in Antarctica or in an igloo in Egypt or something like that. Like that's how this delusional, bipolar fucking individual acts. Okay. Okay. So I'm going to keep moving on. Once notice is given or the motion is filed. Oh, so I can just give notice. I can give notice on the 9th, and then that gives them 14 days. And then if after the 14 days they don't withdraw it, then I still have the balance of the 60 days to file. Now I'm seeing why this took so long to play out in California. I see. And in Georgia, actually, with Kuchar. Okay. I'm getting it. Actually, it was easier in Georgia because Georgia doesn't have, I don't know. I don't need to worry about Georgia yet. See, the ringmaster has a lot of wrench wenches, and the wrench wenches have started sending me frivolous, meritless, grammatically incorrect communications. And one of the wrench wenches is in Georgia, and one of the wrench wenches is in Texas, and another of the wrench wenches is in Hawaii, and another of the wrench wenches is in Pennsylvania, and another of the wrench wenches is in New Zealand, apparently, and then another of the wrench wenches is in Michigan, apparently. I mean, It's a global frickin' problem. Okay. Once notice is given or the motion is filed, all proceedings between the parties, including discovery, are stayed, though the court may allow limited discovery if the parties require it to substantiate or resist the motion. Section 4, paragraph 1A, 4, I don't know. The court must then hold a hearing on the motion within 60 days of the filing, unless the court orders a later hearing to allow for discovery or for other good cause. Section 5.1. Section 5, paragraph 1. Court must rule within 60 days of hearing the motion. Section 8. To have the SLAPP action dismissed, defendants must first establish that their speech is covered by the act's scope, and plaintiffs must fail to establish otherwise. Section 7, paragraph 1A-B. The court will then dismiss the action if the plaintiff fails to establish a prima facie case for each essential element of the claim. If the plaintiff satisfies this burden, a court will still dismiss the claim if the defendant establishes either that the plaintiff has failed to state a claim upon which relief can be granted. Yep. The same standard used in a traditional motion to dismiss, or that there is no genuine issue of material fact and that the defendant is therefore entitled to judgment as a matter of law. What do we used to call that? My law school buddies and I, Jamal. Oh, wait, Jaamol. Yeah, Jamal. The same standard used in a traditional motion for a summary judgment, MSJ, to resolve claims before trial. Section 7, paragraph 1C. All right. If the court grants a special motion for dismissal, the defendant will recover court costs, defendant would be me, and reasonable attorney's fees. Reasonable. I don't know what's reasonable in Washington State, but here in Massachusetts, it's $2,500 for a consultation, for a 1-hour consultation. That's how much it costs. So, and litigation expenses, section 10.1. However, if the court denies the motion and finds it was either not substantially justified or intended to delay, which it's not, I'd like this to be over with like before it even began, the plaintiff will recover these fees. Section 10.2. If the motion is denied, the defendant may immediately appeal within 21 days. Section 9. Washington previously adopted an anti-SLAPP law in 2010, but the state Supreme Court struck it down in 2015, finding that it violated the state constitutional right to a trial by jury. Let me just read this again. Washington previously adopted an anti-SLAPP law in 2010, but the state Supreme Court struck it down in 2015, finding that it violated the state constitutional right to a trial by jury. But isn't the right to a trial by jury for the defendant, not for the plaintiff? The Washington state constitution allows a plaintiff a trial by jury I mean, that's mind-boggling. That's mind-boggling. That is mind-boggling that any state in the United States would have a law that's guaranteeing a plaintiff constitutional right to a trial by jury. Good God, no wonder lawyers are so rich. Okay. By authorizing judges to adjudicate factual questions in non-frivolous cases without a jury trial. Davis versus Cox, 351, Pacific 3rd, 862, Washington. I don't know. I was so bad at Blue Book citations. Like that was another reason I got a C in my freaking legal writing class. Okay. Abrogated on other grounds by Maytown Sand and Gravel LLC versus Thurston City, 2018. So the first one was in 2015, 2018. The law required courts to evaluate whether plaintiffs had established by clear and convincing evidence a probability of prevailing on the claim, taking into consideration pleadings as well as supporting and opposing affidavits stating the facts. Washington, blah, blah, blah citation. The Washington Supreme Court held that this standard allowed trial judges to evaluate disputed evidence and improperly resolve cases before trial. Davis, 351, blah, blah, blah. UPEPA's drafters avoided this problem by drafting the new law to track the existing standards for pretrial dismissal of claims. Specifically, it allows defendants to bring motions for summary judgment much earlier in the proceedings rather than after a lengthy and expensive discovery period. Thus, the new law does not cause the dismissal of a claim that would have otherwise survived a motion for summary judgment, and it therefore avoids running afoul of the right to a jury trial. Okay, that all makes sense to me. Let me see if anyone's watching, and if so, if there are any questions. Okay, two watching and nobody's saying anything, but thanks for watching, I guess. Okay, well, have a good night, everyone. And I will try to get closed captions. I do love closed captions. Normally Zoom does the captions for me. Let me see. Okay, so it's turned on now, but I don't know. Is it showing up on your screen? Probably not. Oh, it is showing up on your screen. Okay. Okay. Maybe I'll need to re-record this with the captions on. Any other questions? The chat is open. Going once, going twice. Thanks for watching. Appreciate y'all. Have a good night. And remember, we, these people, do not consent to frivolous, meritless, vexatious, nuisance lawsuits, especially not in Washington state.